Hola amigos y bienvenidos al expediente semanal.
Hey guys, good evening, or at least it is here, or just barely. I'm sorry I'm a day late and $1 short, but it was a pretty busy week, and this is as soon as I can get to everything. So let's get into it and see what's going on. And not only have there been a lot of cases online, of course, but I had like 2.5 days of hearings this week. So, but that finished, thank God. All right. Let's see what we got, because yeah, we've got the Delphi case, we got Tim Ferriter, man, we got all kinds of cases. Let's see what. First, let's start with our friend Darrell Brooks, who had his transcript due on the 18th of November, and guess what? That's today, and guess what? It actually is being filed. So that means he can proceed, or his attorney can proceed with evaluating his appeal based on the transcript and ultimately reach the conclusion. I don't think so. So anyway, that's what was going on with his appeal. So I don't think there'll be another extension filed, because it appears, at least the last time I looked at the docket, the court reporter was already in the sentencing days. So that looks good to go. So finally he'll be able to move forward with this appeal and get some subject matter jurisdiction up at the appellate level, see what happens with him. So I wish him the worst, and I think that's what he's going to get. And of course, as you know, he has an appointed counsel. That counsel will evaluate the situation and then either file an appeal or potentially a no merit report. And if that is sustained, then that'll be the end of it, unless Brooks wants to carry on himself or hire his own lawyer. So let's see who is making it here in the evening. South Carolina. Yeah. And it is quite dark up here in Raleigh as well. That's killing me, man. This no sunshine is tough. Michigan, a lot of things happen in Michigan. Some cool and some strange. And Los Angeles, well, that's all of that on steroids, right? And then Kansas. I would say you're not in Kansas anymore, but you are in Kansas. And Dallas, Texas, home of one of the biggest conspiracy theories in America that's probably true, the JFK assassination and what really happened there. All right. Oh, well, look at that. Calgary. That's awesome. West Virginia. That's awesome. Missouri. Wow. Everywhere. And, all right. So let's look at that. We got the late situation here. Okay. So that's like, what, 5 hours behind? Yeah, a little over 11. So thanks for tuning in. Let's get the volume up. Let's get some interesting stuff going so you can make it through this and stay awake. Some happenings down in South Carolina with Alec Murdaugh and Judge Newman. Goodbye, Judge Newman. We hardly knew you. He's retiring soon, and I think his time with Murdaugh is coming to an end. Liverpool, very cool, very cool. Home of some cool music in Washington State, home of Mount Rainier and other things. Illinois has certain areas of that state has some excellent corruption in it, doesn't it? So we all have pockets of that. But I was thinking of Chicago there. All right, so financial crimes are settled, right? And there seemed to be some mystery about that. Well, like, why was he hanging on or whatever? Well, Harpootlian had said before that he kind of indicated, at least what I heard, we could get these cases worked out if the state would not insist on using basically the 3 strikes law for a life sentence. And I think they finally agreed to that. So they have some amount of years, but they didn't go for the automatic life sentence. That's my understanding of it. And I think that's why they were able to finally settle all these things. So achievement unlocked for Murdaugh for not getting a life sentence on the financial crimes. And so now he can, because his whole goal is to try to avoid life sentence for all the money he stole, all the people he ripped off, hoping that he can get out of this murder crime. I'll go back to that one. The murder verdict that he's got. So the situation there is that Judge Newman has recused himself for the motion for new trial, so some other judge will handle it. And likely there'll be an evidentiary hearing, and that judge will evaluate whether the judge thinks that this happened, that the clerk said these things to the jury that we've all heard about or not. And if it did happen, I think it's likely there would be a new trial. Of course, it could be good or bad or whatever. Some people feel like that Judge Newman's rulings in terms of letting in so much of the financial crimes evidence could have exposed the verdict to a successful appeal. I'm not sure about that. I haven't researched it. I understand the issue. But if he were to be retried, then, that might be different with a different judge. But of course, that judge might do something that people think is wrong, right? So a different judge. And it would certainly be to Murdaugh's benefit because he's convicted the first time. So why not try again? And plus, he knows everything the state's going to do. And I would suspect one of the things they would do is maybe be less laughable on the tiny ninja part of it and come up with some better excuse for why he forgot or lied about being at the murder scene only minutes before his family was murdered. So whether he did it or he didn't do it, that looked very bad for him, and he's got to do better on that if he goes to a new trial. He got off so lightly for these crimes. Yeah, he did. That's true. And I hate to say it. Sometimes for these big money crimes, it's almost like, yeah, it kind of does pay, doesn't it? Because you might get away with it. And if you don't, you have it for years. And, then you get some kind of punishment like this. So here's a good question. Why did Murdaugh's attorney withdraw the recusal request? If that's for the financial crimes, then that's because they worked out this plea deal and Judge Newman was amenable to that. So they've got to let the victims talk and stuff, but the judge seems very inclined to proceed with the plea bargain. So, and Judge Newman himself, I think, removed himself from the murder new trial motion. So that's why I think it's just because Judge Newman was prepared to accept this plea. So I think that's why that happened. Wanted the prosecutor to show all the guns that he knew weren't the murder weapon at the trial. Yeah, I'm not sure about that. Of course, everybody was showing guns and stuff because the defense wanted to show how you might not hear a weapon, so they had some weapons, but yeah, showing guns that aren't the murder weapons. Yeah, that's an issue. Are they allowed to bring up new evidence? Yeah, I mean, if they do a new trial, yeah, that would be just a new trial, and it could be new rulings. So we'll see what happens with that. I don't know. They still got to convince the judge that Clerk Hill talked to the jury about the trial. But if they do that, I think the law is on Murdaugh's side. I don't think it's really but they said it didn't bother them kind of a thing. That is essentially the standard if it's some random person in the street or something. But when it's a court, when it's an officer of the court or somebody associated with the court, the standard changes a little bit because the weight that they are assumed to carry with the jury. So, but it still could be the case that the judge may go, no, I don't think that happened. So I guess we'll see on that. Where is Clerk Hill these days? Not on a book tour, maybe, although she did do that for a little bit. That was a bad idea, even if she didn't say things to the jury, which I hope she did not. But last night, Dateline had a 2-hour show with interviews with the detectives. See, this is how busy I've been, because normally I would have probably seen Dateline because I like Keith Morrison and all the rest of the crew there, but I've only been doing other things. So now that he's been sentenced for the financial crimes, do you think they'll bring him back up for the murder trial? Yeah, I do. And now how much you're going to talk about him would be different, but in theory, this is part of the motive, okay, for the murder, if you buy that. And I think the question is not so much could they bring it up, but it's how long do they do it? Is this a financial crime trial or is this a murder trial? That was some of the argument with Newman, that the volume of the financial crime evidence was so much that it was unfairly prejudicial to Murdaugh. That's the idea anyway, at least for the murder. So, he's had some bad news getting convicted of murder and, of course, and all that. But look at him. He's in pretty good spirits there. You have to give him credit. He doesn't rattle too easily, does he? Anyway, he's in jail for a long time, but he's trying to cobble together a situation now where someday he sees the South Carolina sunshine again. All right. Yeah, hopefully not 3 weeks on the financial stuff. That's kind of crazy. And you kind of don't need it anyway because he's already pled guilty to these things. So, yeah, they shouldn't do that much of it. Well, let's go to this eye drop case because we talked about that. And she's catching the red eye back to Prisonville. And there was not a not dry eye in the place as she's convicted of murder for poisoning her friend or whatever with Visine or eye drops. The defense partially was that the victim liked vodka and she also liked Visine. So that's from the Adelson Institute of, I can't believe you're going to go with this defense, but you're going with it and you're doing it with a straight face and it's not going to work. Master's program that they have there. As he, of course, said that the blackmailers put him on a payment plan. No, I don't think so. And, like a little vodka, maybe. And this drink right here it's got nothing in it but juice, unfortunately, sadly for me. But I'm not tempted to season it with eye drops. That's not a spirit that I'm interested in. And the jury didn't buy it for the victim here. So, I don't think so. So now she's facing a life sentence and a little more because she's got, I think, 10 years or something for the stealing part of it. Now, remember, a life sentence up there is, it's potentially life or potentially not. Even Darrell Brooks had to have a sentencing hearing and a judge had to consider the factors and all those things because there's life and then there's life. There's life and then you can get out. They don't call it parole anymore, but whatever they call it, it's extended supervision or something, but it is parole. Or potentially you don't get out. So the judge has to make those findings. So we will see. Yes, thank you. Thank you very much. See that you guys are helping me because I'm not on top of everything this week, but it was a Latin King eye drop. And that, if only defense counsel had thought to bring that up, this case could have turned out differently, of course. So thank you. New Jersey. Yeah, it's early sunset there like it is here. It's pitch black at 5. It's not the best. I don't like it the most. Sentencing is December 7th, Pearl Harbor. Not looking good, I think, for her. I didn't like the defense lawyer. I really didn't see much of this case. Only heard that, I think, a little tiny bit of it in that part about, she liked Visine. Yeah, so Sue Opera there for the closing argument said that she was in a gallery, right? I think she was watching fellow DA perform there. So that's cool. Let's get into this case because we got to get into this case. We've got some more that aren't as dramatic as this one, but let's see what is happening in the Richard Allen case as we put the facts on the back burner temporarily and talk about what's going on procedurally with this case and in particular with the judge. As we all know, she, I don't really know exactly what happened, but we may know in a week when we get this transcript from the Chambers meeting, but they met in Chambers. The defense attorneys leave the courthouse. The judge informs people that they've withdrawn / intended to withdraw / will be filing withdrawal documents. And that's it. And then, of course, Rozzi comes back and says, I'm not leaving. And then the judge says, but I'm not going to recognize that. I want it struck from the record. I want the clerk to remove it. And then we head off to the Indiana Supreme Court. So let's see what's going on with that. So, all right. So Supreme Court action, I think I just left the title on here from last week because I'm really talking about both here. So she was kind of accused of being a sealing fan in Action 302, and sealing documents against rules was the allegation, and not making things public that should have been. And then, of course, the whole late breaking part about saying, I'm going to strike these from the record and I want them struck from the chronological case file. Not going to look at any of it. So that's what the judge has responded to, and we'll look at that in a moment. And then she's got to respond to the Action 311, which is really that's the real one, by 27 November. That's the one that says we need this transcript. And the Supreme Court has told her either produce the transcript or put in writing why you think you shouldn't have to. They're looking to void the disqualification of the attorney, saying that she acted outside the scope there, and they want her taken off of the case. So that's really the Action 311. All right. Now, let's see what the judge said here. Because, all right, I think we went over, I made a 1-minute video of it, and other people have talked about it for longer. The judge issued an order in the case. And that order basically was saying, let's take those 118 documents that were in the zip file, let's put them on the CCS the right way, make those available the right way. Let's unseal this thing from the prisoner and the thing from the sheriff. Let's put these things from Rozzi back onto the record, even though I'm not going to pay any attention to it. Yeah, so obviously what that was to attempt to moot this action at the Supreme Court level. So, all right, basically everything you ask for in this action, I decided to go ahead and do it. So thanks, but we don't need to do anything more. And remember, this is not about whether the judge is necessarily doing the right thing or wrong thing or whatever. What you have to remember is when you head up to the Supreme Court level, particularly on something like this, it is the height of procedure, the height of technicality, formalities and things like that. They really matter. So that was part of what her strategy and her counsel's strategy was to moot this. And then they make the argument basically saying two things. One is, you didn't even make a motion in front of me for all these old things, okay? The 118 documents and the prisoner letter and stuff like that. You didn't make a motion to put that stuff back on the record, so you shouldn't be heading straight to the Supreme Court. And really what you're doing here is you're strap hanging off of that for the new things that I've struck from the record and the fact that I threw you out of the case. So you're putting all this up to the Supreme Court about documents, but the documents you really care about is the October 25th, 26 filings. And so that's when the judge in her filing to the Supreme Court says that it's expeditious only to the extent that it seeks to reinstate the October 25, 26 filings. And she's probably right there. If Rozzi had never been kicked out of the case, let's say that didn't happen, that he and Ball were on a case, and they didn't like how the judge handled the 118 documents or whatever, and they just file an action up at the Supreme Court and they didn't ask her first, it's highly likely the Supreme Court would just send that back down and say, no, you got to ask the judge first. And if the judge says no, then, and you think that warrants this kind of relief, then you can come back. So that's kind of a reasonable thing, except for the 25, 26 filings did occur, and she did order those struck from the record. And so her second argument to that is, well, hey, he's got plenty of lawyers. He's got lawyers out the wazoo because I've appointed some new lawyers for him. He's got lawyers entering limited appearances. So somebody else could have made these motions for these things, but plus I did it anyway. So to some degree, it's like, well, all right then, this is largely a moot situation. And my opinion, as I said, when the Scott file this was an avenue to get to the issue of these attorneys being thrown off of the case. But in the interim of filing this, of course, she held that hearing at the end of the month, last month, and said, you're disqualified from being on this case. She didn't just stick with you withdrew, right? Originally, it was you withdrew, and I won't look at any paperwork that you file saying you're not withdrawing or you're trying to appear back in the case pro bono or whatever. She said you're disqualified. And then that led to largely the reason for the second action, which is the whole point of this thing, really. So this first action is kind of a sideshow to what really ought to be decided by the Supreme Court. So it kind of doesn't matter. If she hadn't attempted to moot this, then probably she might have gotten slapped here, but she's kind of taken it off of the game board a little bit. But it's not going to stop what's coming on this next action 311, which is due this coming Monday. So let me see what you guys are saying about this. Gull should be removed from the bench. Yeah, you never know. Hi, Nicola. Thanks for staying up so late, and thanks for giving out some memberships. I'm going to get this member stream going in the next couple of days. I've got a couple topics, so I'm going to make it a two for one since I was behind this week. All right. Thank you very much, and I hope you guys are doing well. Me and Mrs. Southern-in-law hope that. This is a good comment. This is a cluster, and I agree with that. This should not be happening here. So let's take a little bit more of a look at what's going on here. Because like I say, it kind of doesn't matter what she's arguing here because she has essentially given away the game, right? She said, okay, I'll put all that stuff on the record. That's cool, but you're still disqualified. And that's what matters. And this transcript, if it supports the disqualification, you need to get that filed. And probably going to need to file that anyway because there's nothing on the record, in my opinion, that supports the attorneys being disqualified out of the case. Whether they did something that would warrant the extremely rare idea of throwing a lawyer off of a case, they may have done that, they may not have done it. I'm thinking they didn't, but if they did, that should be on the record. Now, that's not to say they're perfect. I'm not one of these people that says that if I think that the defense is right here, then everything they do is perfect and right. That's not the standard for any of this. The standard is, even if they did something wrong, should what happened to them now be they're thrown off of this case? And I think if the judge didn't like the pattern of behavior of these attorneys, she should have gone on the record earlier and put that there and sanctioned them in some other way, because again, you're supposed to scale sanctions up. Not always. There may be something super egregious, but generally the first thing that happens to you in a fight in the court, whether it's with a judge or whether it's with the other party, is not the worst thing that can possibly happen to you. They usually, start amping that up and build a record of noncompliance. Let's see. Why are judges so reluctant to recuse themselves? It's a fair question, but of course Judge Newman just did it, right? Or he spent the whole case over this, the whole time over Murdaugh's case, but said, "Yeah, I'll recuse myself from the motion for new trial," and he wasn't doing it on a financial crimes case, and I think defense may have had some good arguments there why he should, but ultimately they wanted to plea bargain out and they got the plea they wanted, so I think they're probably happy about that. That's the best strategy they can do right now. That's for sure. I think I've said it. I think the judge has succeeded in making this largely moot, because when you do the things that they ask for in the order, then that does help cause it to be moot. But does that really look good, though? Does it look good that I think the judge is going to say, well, it looks good because all they had to do was ask me. Well, man, if anybody had ever asked me, I would have made all this stuff public right away, man. Who knew, right? And then the Franks thing is only confidential because it wasn't redacted, right? I think you have to look at that in the context of this other action, the 311, and see whether you think this judge is being impartial to these guys or not when she has, in fact, thrown them off the case. And you can't pretend like none of this was in her mind when she threw them off the case. That's my opinion. So I haven't seen, and somebody's saying, why is the AG getting involved now? I have not seen what they have filed. I saw the brief from the media, but I haven't seen what the AG said. So I'll look at that. And if I can answer your question, because there's a question here, what's the role of the AG motion from the 16th? I have to say I didn't see it for either action, but that obviously doesn't mean it's not there, because I've not been able to look at all of it. But the last time I did look, the media had filed an amicus brief. So I'll check though, and I'll get you an answer in the comments after this over, because I don't know it right now. And that's what I'm talking about here. Here's the Indiana Broadcasters Association filing an amicus brief saying the judge shouldn't be hiding things off the record. You got to follow the rules for concealing documents and things like that. So again, that's could be to a large degree moot at this point. And I think it rolls over to the 27th, and we see what the judge responds with then. What's interesting is, because people are like, well, the defense was saved embarrassment, right? That they withdrew because they didn't want to be embarrassed, which would not be a good reason to withdraw of a case. Withdrawing because you think it might hurt your client is a good reason. And they said both of those things, I think. But if what she was saying had so much to it and was so embarrassing and it really showed it out, why is the judge the one who doesn't want to provide the transcript when the defense is asking for it? Again, I'm not typically go one side hard or the other on this one, but to me that definitely tilts to the defense side, right? Plus she didn't put on the record, which she could have done even at the end of the month on the 31st, when she said, well, you're disqualified. Here are the reasons why you're disqualified. Then it would be on the record for the Supreme Court to look at. And right now, as far as I know, the Supreme Court would have nothing in the record to show what justifies taking these lawyers off the case, because it's all in a secret in chambers meeting. So I don't think any of that looks good. That's my opinion. So here's the question. Why do they have to redact their Frank memo and the state doesn't have to redact their documents? Yeah. I wasn't sure, of course, obviously I wasn't sure why it got made confidential, but now we have this reason, right? And if all it is the victim's names, then that seems pretty thin there. And were they told that? I don't know, because like you say, I think there have been a lack of redactions in some of the other documents. So if your view is, well, this is a selective situation here that really, hey, maybe this was put as confidential just because of the whole scope of the Franks narrative that they put out there about the Odin thing and stuff. So by using the minor names, it's a reason to make it confidential and then not say anything else about it is really designed to tamp down the Odin thing. I would understand where you're coming from on that. So I think, it would be easy enough to redact that. Now she's invited the new counsel to do that. If they want to, they can file a redacted version and it'll be on the record. Of course, everybody's already seen the unredacted version, and you're exactly right. Everybody knows who's murdered in this case. if there was anything that should be redacted, it would be personal information about other people, but I don't think that's what was referenced. It's weird these free lawyers are fighting so hard for this alleged murderer who told his mom and his wife he was one. Well, it is weird, and the whole thing's weird. But here's kind of the thing, though. If you practice there, especially if you largely practice on the defense side, particularly, but any lawyer, I think, would look at this and say, okay, whether he actually committed the murders or not, he's in this system, and there should be a process that gets followed. And when you see lawyers actually thrown off of a case for something said in chambers that's not on the record, that's like an alarm bell, right? So I could see lawyers who may or may not, although some of these do probably think the guy's innocent. But even if you didn't, you could take the position that I'm going to support the defense here because they shouldn't be thrown off the case based on things that are not on the record. That's not the way we should run this process. So if I were involved in it, I probably would, fight pretty hard on that. And I think he probably was involved in it, but I don't know the whole case, right? So, but I can think that and still think, no, this is not the way that this is supposed to happen. If you test it first and go, well, I think he did it, so I don't care how the system works, that sucks. And if you only care about how the system works because you think he's innocent, that's okay, but that's not really the point, right? The point is the process should work, period, regardless of your personal opinion, because ultimately the jury's supposed to render the verdict, right? So I think he deserves a fair process, right? And I don't know that he's getting it here, regardless of what he actually did or didn't do in the case itself. So we'll say, yes, evidence missing eye is itching. It's a blasphemy. I'll have to watch out here. I don't know if my house is protected or not. So that's, about the inmate letter and stuff. I don't know if that inmate's full of it or if he's telling the truth or whatever. Putting all that stuff is super confidential. Yeah, I don't know about that. And why is he in prison? Well, we know why they said he's in prison is because they want to keep him safe and everything. But Kohberger's sitting in jail. And, if I think Kohberger's guilty and if I think Richard Allen's guilty, how's Kohberger any safer than Richard Allen would be, right? They're both terrible if they both did it, right? So I don't know that I'm buying the whole he needs to be in prison thing either. I didn't buy it back before all this drama. I didn't agree with the defense motion because it had a lot of drama in there, a lot of over the top baloney and stuff. But their core point that he shouldn't be treated worse than other people similarly situated in the past on charges like this. He should have access to counsel. He's not convicted yet. I think those were all really good reasons. Some of it was a little over the top, but it gets back to your question, like why, right? Like why does he need to be there? He needs a fair trial. That is absolutely right. Okay. So good point. What was her response to Richard Allen? Something about denying his request would not be an undue hardship. So on this first one, part of the thing is like, you don't need to get involved here, Supreme Court, even if remember when we talked about the judge could operate like within a lane and everything. So they don't want to be hearing super technical things that really don't amount to anything. So one of the further arguments they have is it's not really a big deal here. He doesn't need this going on because he's got all these lawyers. They can file all the motions they want. This is they're making a mountain out of a molehill kind of a thing. But I have to say, I look at this response to this first action and say this is like a pregame show right here like this, but it doesn't mean anything compared to what is going to come the next Monday, which is really where the substance should hit, because there I think she needs to justify to the court why she's not providing a transcript if she chooses not to. I think she needs to justify to the court why she disqualified these attorneys and why none of that was on the record. Okay, because it's always possible that the Supreme Court could say, okay, because they will punt things sometimes. They could say, as it exists on the record right now, we cannot evaluate this order that you have. Like, we can't sustain it, but we'll send it back and give you the opportunity to put on the record why you did the order you did. That's always a possibility that could happen. I don't think it will here, though. I think they'll probably get to the merit of things, but don't be surprised because, like I say, you're in the most technical of worlds when you enter that one. Kohberger's clearly innocent. If he doesn't flee across the country and throw stuff out at neighbors at 3 a.m. Well, and also stand in your kitchen with surgical gloves on at 1 a.m. That is, of course, only the circumstance thing. But if your DNA has a habit of floating through the air and landing on a knife sheath that you are going to need to say that you weren't in possession of the night you were driving around, but you don't really remember where, so that your trace DNA, which is not necessarily meant you touch it, but if that happens to easily float through the air or touch something or whatever, then wearing surgical gloves at all time is probably just a good thing to do. How is unredacted a remedy if his new lawyers don't want to do it? I'm sorry, I lost my train of thought in terms of which document that's talking about. Now, I will say, if his current lawyers are representing him, then they're the ones saying what he wants to do. And if they don't want to do it, then there's no harm to Richard Allen because they're his current representatives. And that's why I say this is all a sideshow to the main event, which is, are these lawyers, the original lawyers, thrown out or not? And, I don't think Richard Allen has really had the opportunity to say anything out loud. I mean, I know he signed that letter saying he wanted to keep his original lawyers. He hasn't said anything about these new lawyers, to my understanding. So I think this gets to the point you're trying to make there is, is this transition to the new lawyers really what he wants? Is that his counsel he wants? And if these other guys are willing to represent him, he should be allowed to have that. He shouldn't. If you can have other counsel, you shouldn't be forced to take the counsel that the state is pushing on you, appointing for you. So I think that's getting to the point you're trying to make there. So shouldn't the Supreme Court decide on that portion of this writ? Yeah. See, I think, like this writ now amounts to like this much of it because the whole thing really is, and the Judge Gull did say there that you got all these lawyers, and not just the lawyers she appointed, but some of these other lawyers appearing at the appellate level. One of them has entered a limited appearance, and so Judge Gull is saying they could have entered a limited appearance and say make all this stuff public. So it's really talking about a predicate to have filed this action in the first place. But I still think it's a sideshow for what is the real thing happening. Let's see. Yeah, if Richard Allen did not do this, then of course this is sad because this is a long, drawn out process, and it's devastating because a lot of people think they're certain they did it or think he may have did it. A lot of people think that. I think the circumstantial timeline on him is pretty bad. So if he has a defense that works, that takes away that feeling or never convinces the jury that he is guilty, sitting in jail for 2 years or longer, prison, is terrible. It is terrible. It's terrible. It's also, none of these things are ever just terrible for one side. It's terrible for the families because this lingers on. And, if they believe he's the guy, they don't want all these shenanigans happening that could potentially put a accurate verdict at risk, right? So this is terrible for the family, terrible for the witnesses, terrible for Richard Allen and his family and all that. It's no good. You want a smooth process that gets you to the trial and gets the evidence out there, and then the system do the best that it can do. So slowing it down, it sucks, man. Yeah, the alleged Google beach serial killers in the county jail, Kohberger's in the county jail, and Richard Allen's in the whatever Supermax thing or whatever. So I didn't agree with that decision either at that time. So, but I think we got another week here before we'll see what really happens, and I will try and look and see if there was something from the AG that I missed. So will Judge Gull, will this Gull end up on the rocks, or is she going to fly with the Eagles of Justice? I think we'll know soon. The Supreme Court will have to have some period to decide, and there may be a request by Allen's attorneys, his appellate attorneys, to reply to the response. And if they do feel the need to do that, that'll slow this down probably a little bit because they got to have some time to do it. And the Supreme Court will have to have some time to evaluate what everybody's saying, read the transcript, any attachments and all that stuff if the transcript's provided. If the transcript is not provided and the Supreme Court wants it, then that could take some time. But they might also go, well, you know what? You didn't provide a transcript. There's nothing on the record, so we're vacating your order and we'll take you off the case. And then none of us have to worry about it anymore, do we? So that could happen too. So I think we'll read what she says when she says it next week or the week after, I guess, the Monday after. Yeah. And we'll be able to tell whether she's got good arguments or not. You never know until you read both sides of the thing. But ultimately, you're saying she needs to recuse herself, and yeah, Judge Newman did it, right? So, yeah, I think that's ultimately going to be helpful for her and everybody else eventually. Or, of course, the court might do it, but we'll see. She hasn't done it yet, and she may not feel the same. So Tim Ferriter, our buddy there, is going to spend some time thinking inside the box. The judge gave him, I think, 5 years I don't know what that comes down to, if it gets out earlier than that for good time in the box and all those sorts of things, and not trying to touch any thermostat, which he won't have access to. So he's gonna get to live the dream. He's gonna, all the things that he thought were so effective for his son that would help his son improve his disposition and his outlook on life. Now Tim is getting the benefit of that. So he's going to come out of here a much better person. This is really a great situation for him to have this opportunity to grow inside the box. And that stunned look on his wife's face there will probably continue as her turn is coming. So let's go back to Bryan Kohberger. And you know about the drama there, don't you? No, you don't, because it's Judge. I'm just going to leave his picture in here every week that there's no drama until there is some drama, because he's doing a good job of keeping this tamp down, in my opinion. So everything is moving on in that case. It's slow, but it is quite technical because there's all this DNA evidence and stuff like that, and experts have to have time to analyze it. And who knows what else there is or isn't in this case in terms of experts on both sides. I think it's fair to, while I am real confident they got the right dude sitting in that jail there, he has a very good defense team, and I'm going to be interested in hearing what they have to say. I mean, of course, they have some good points, like, to our knowledge, you haven't found any evidence in his car. I think there are reasons why that can be true. I think they're going to have to say that. There can be explanations for circumstantial evidence of DNA, which is what this DNA is. It's circumstantial evidence, not direct evidence. So they can talk about that, perhaps indirect transfer or this, that, or the other. So we'll see. Here's a question back on to Murdaugh. Does he still have federal charges pending, or did he plead all those too? I have to check that. I was thinking that had been settled, but I'm not sure about that. So I'm not going to say. I'm not confident. I think Kohberger's the right guy because his DNA is on a sheath of obviously of the murder weapon, and his car left out of where he lived before the murders occurred, came back. Even the defense has to admit that with that ridiculous alibi of his alibi is, I did leave only shortly before the murders and returned shortly after those, and I did drive around the proximity of that area, but I forgot where I was, and I also turned my phone off. So, and the DNA on the sheath is not there are some people on the internet acting like that's not going to matter to the jury. And it is going to matter to the jury that his DNA is the sole source DNA on the murder weapon. It's a party house. And so, if they didn't find that, that would be great for Kohberger, because it's going to be numerous potential DNA sources all over the place around that thing. But finding only your DNA on the murder weapon, that's a bad situation. So sometimes guys look kind of normal at certain times. That, and this guy, I'll have to say this for Kohberger, he struggled with a lot of mental issues, of course, when he was younger, that seemed to plague him. And, he wrote up that weird survey that I did take. So I'm putting together the circumstantial timeline for this guy, and no individual piece has to prove the case by itself. You look at the thing in the totality and see whether you believe beyond a reasonable doubt he's the guy or not. And now I'm saying I'm confident. I would want to see the case before I would vote on any of these things, but nothing persuades me. None of the arguments put out there yet about how his DNA might have gotten on the sheath in any other way than him putting it there have persuaded me at all. I've heard a lot of people who don't know what they're talking about knives, killing, weapons, or anything else, come up with theories like he didn't have time to do it. Why would he have this on his belt, and things like that, are just making up things for why the defense will have to do better than that. You don't want to be doing the tiny ninja, the payment plan. You're going to have a real reason why that DNA could have gotten there, and then convince the jury that out of this, potential that this is the reason this DNA is there. So that's why I think it, but he's got a really good defense team, and they have not been out in the public yet pushing the theories that they have. They've only put out some of that, like there's no evidence in his car. So, I want to hear what they have to say too. But as it stands right now, the probable cause they used to arrest him is certainly valid under the law. That's my opinion. But, well, see, now here's an interesting thing, because Kohberger, when he was pulled over in that car with his dad, and I think he did look pretty crazy in that video. Sometimes I clip that picture, but I feel like when he comes to court, he does as good a job as somebody can of looking as neutral and presentable as they possibly can in a courtroom. And sometimes the person's innocent, and sometimes they're Ted Bundy, and they can look normal. And I don't know for sure which he is yet, but I think he's doing his lawyer a favor by not, staring at people or glaring, and he doesn't have a weird tattoo and stuff like that. And he's not doing anything horrible. So I think he does fine when he comes to court, and they got him in street clothes and stuff like that. But I know that some people feel like when they look at him, they're looking at a crazy guy. And I feel that too, but I feel that I'm bringing that to it rather than him projecting it to me. So, yeah. But anyway, fair observation, I feel like. Again, Judge, I salute you. There we go. So, all right. So how about Donna Adelson, right? I feel like when she and Harvey rushed up to the airport to get on the flight to Dubai and then to Vietnam, that there's like Phil Keegan there with a mat. And he's like, Donna and Harvey, I have to tell you, you're the lamest team and you have been eliminated from the race. And now you're going to jail. Because they are lame, and the whole idea that you're going to run to Vietnam is absolutely ridiculous, and certainly is more evidence to me of her belief that she faces some serious consequences for her involvement in this situation. And it doesn't look like that she thought the payment plan defense would work for her or any better than it worked for her son. Let me go back here to Kohberger for a second. It looks like he's smirking, and I think Murdaugh and his lawyers up to something else. If you're talking about Murdaugh, well, Murdaugh does some interesting things. He was upbeat for a dude in the situation he's in, but he was getting some cases settled, and lawyers like to settle cases. And why not make the best of whatever situation you're in? But I'm a lawyer who happens to think that Murdaugh's where he needs to be, because I think he killed his family, and a lot of lawyers think that either the case wasn't proven against him or that he actually didn't do it. But my view is, he did it. He did it. That's my view. I wasn't there, so I'm as fallible as anybody else. And listen, if you examine the facts and you have a rational mind, okay, and you're trying to reason and see both sides, if you do critical thinking, then the lawyer does not have a better insight into whether somebody's going to be found guilty than you do or not, any more than the clerk who sells lottery tickets knows what the next winning number is, because the jury in these cases are average, normal people. They're not trial attorneys or lawyers on YouTube or whatever. So when somebody asks me, or I just can't stand it and I have to give my opinion on a case, if you're critically thinking and you have a different opinion than me or the same, we're all on equal footing, right? I don't think that I know better than you do about how these cases will turn out, but I feel like Murdaugh did it. So, okay. So one thing we had here in Donna's case was the scales of justice, because on the warrant, she was listed as 140 pounds, but on this booking thing, she was listed as 112. So, if there was a question, you're like, can that really matter? And no, it won't matter. I mean, you don't have to know what somebody's weight is when you're getting them. You're just trying to describe somebody the best you can. And sometimes people list an aspirational weight, and sometimes they look at you and guess, and sometimes you're wearing more heavy clothes when you get weight. So who knows on that? And I think she even has her eyes listed as brown in one thing and then hazel in another. So her lawyer will not be making a motion to throw out the warrant based on weight discrepancy or eyes or something like that. So that won't work for her. Everybody knows who she is. And that's pretty funny that they were able to keep an eye on her and catch her actually trying to leave the country, and dumb enough to talk to Charlie about it. So her flight got bumped. So she got another bump, and she was bumped into jail, and we'll see what happens to her. Yeah, here's a comment. You really should not murder, but paying more people to know your bad deeds is the wrong direction. Yeah. There's a lot of people in this situation here. Too many people. Not the smartest way to handle anything there. Just awful. So, what's strange about this is you can have domestic violence, and a lot of cases end up being one side or the other in some kind of divorce situation. Murder is the other. I mean, it's some of the worst cases near where I live. The Jason Young case, the Nancy Cooper case, Adele Hickmott case. The suspect who you think it was going to be, the husband or the estranged husband or the angry husband, and it can be the wife too, that ends up being the person. But they made this a whole family affair right here, didn't they? Because I feel like that the two people here, Donna and her son, aren't the only two people maybe who knew what was up. And we'll see if any further indictments come or whatever. But I think, they've got Donna maybe involved in the money on this. So we'll see. She's, I wish I had clipped this, because if you saw her when she was in, I guess, for her first appearance or whatever, and the judge was kind of cracking jokes and stuff like that, she was not enjoying the judge's humor. So unlike Murdaugh, she's not making a everyday shine with sun. From her own mind, I think she is upset that she's where she is. So that is cool. She'll claim dementia. Yeah. Maybe she could try it now, but I think it's not going to work. I don't know what she'll do. The payment plan thing, well, they got a dry run on that. That won't work. They'll have to come up with something else, I think. And here's a very good comment, I think. The poor little boys. And so, yeah. So your whole theory is you care about your grandchildren. That's what she was talking about with her son on the phone. Taking care of the kids. You're not taking care of the kids, because murdering their father is one way of not taking care of the kids. And another way is having it be a family-wide conspiracy. So now the uncle's in jail. She's going to jail. The mom could be indicted at any minute for anything. Is having to testify all the time. So what her view of taking care of the kids, I am sure in that phone call, I think the context of it was in terms of like making sure they have some kind of trust account or whatever. Oh, great. Yeah. Because as long as you have some money, then you're always happy. That's all it takes to be happy, right? If that's true, how come your stacks of money didn't make it work out for you and your family, and you end up hiring some weirdo murderers, and now you're all going to jail? Sometimes being poor can be a better route to happiness than being evil and having some money. I think Wendy was complaining. Here's a comment. I think Wendy was complaining to Donna and asked Donna to ask Charlie to take care of Dan. See, I think there's a lot of thoughts like that. So I don't know if they have enough on Wendy to say, that she was part of this conspiracy or not, or slightly aware of it, or didn't know but suspected it. I'm not as familiar fully on her case, but I don't think they have her tied directly to money like they do. I think that her mom is, even though she watched it. The whole Adelson family needs to be locked up. Well, how bad can it get for this family? I realize they're not all locked up, but I mean, wow, they are pretty much destroyed at this point, aren't they? So that sucks. So, should the mother have custody? She hasn't been charged with this, and I don't know the full extent of things, but at some point, this is awful. This is just awful, and maybe the other side of the family would be a better place for them to be. But hello from Clemens, and I've been there many times because I used to live in Winston-Salem and work there. All right. So cycle of violence. I don't know if you probably watched this case. As Kaitlin Armstrong is convicted of murder, and she's got 99 problems, and her jail term is 90 of them, because she faces a potential of 90 years in prison for killing. I don't know what to call these people. Here's a picture of the dude in the middle, and I think he was dating one of the girls, but sometimes one of the other girls. But Kaitlin was of the view that if there's another girl in the picture, that what I will simply do is kill them, and then I don't have to worry about competition for my boyfriend. But it's not a well thought out plan, because she commits the murder, and then she ends up having to take off and go down and have plastic surgery and teach yoga on an island and stuff, and still gets caught. She tried to run away with a hilarious video of her trying to run away from the police, but she didn't make it, even though she is very fit, and she's where she needs to be, because she's clearly very guilty. If you didn't watch the prosecutor's closing statement in there, or closing argument in that, it's pretty good. We enjoyed it. He was smiling some in it, but I think it wasn't inappropriate, because it was like, he said, we haven't climbed the mountain of evidence they said that we need to climb. We have climbed to the top of Mount Everest with all the evidence we've got. And he just blew the defense out of the agua. The oldest son got the hell out of there. That's right. I think I forgot that there was one that is gone out of the picture in terms of the Adelsons, I think. I have not seen the mom's impact statement. I think you talk about this case here, so that would be interesting to watch. Hopefully I have some time to watch some of this stuff over the weekend. I got to catch up on Dateline, man. The jury got this one right. Yeah, and this shouldn't have been a hard one, right? I agree with the DA here as he made his closing. Oh, yeah, they got this one. But awful, as you probably know, they had the audio of the murder, played that, and that showed up on YouTube and stuff, and absolutely cruel, right? She shot her twice, and then a few seconds later shot her again in the heart. So terrible. Maya Kowalski will get back to the civil side, but not quite so civil as it was before, because she's filing, I think she has gone to the sheriff's department or the police, one or the other, and made a complaint about an assault that she suffered in the hospital, she says. And then her attorney said they will be launching a lawsuit over this. So that's interesting. So this could be, and he said at the time they didn't know whether the person who they say did this to her, which was abusing a child in a certain way, whether that person was an actual employee of the hospital or somebody who was allowed to roam around and they didn't have adequate security. So, they're setting up either a direct case or kind of a premises liability, negligent, this, that, and the other, and all that stuff. So we'll see how that goes. They're not done firing at this hospital yet. Yeah, I'll go back to Kaitlin here for a second. Ruined lives over a dude like Colin. I get it. He's young and probably got testosterone and stuff because he's cycling like crazy and everything. And there's two attractive women and they're all going around to different places and everything. But here's the thing. Sometimes that kind of behavior just leads to a result that isn't good for anybody. And this one turned out absolutely terrible. And they both would have been better off going somewhere else. And he would have been better off too. So everybody loses in this one, but a terrible case. Anyway, there's Maya in the hospital. So she relayed what she says occurred there. And if it happened, it's very disturbing. It'd be nice if they found out who did it. I don't know that they will at this point. So terribly. How about the Crumbleys? I don't know if you heard about this one or not, but they got an update. They are going to have separate trials. They were pursuing it jointly, but they are now going to have their trials independently. The defense asked for that, and while the state said that's really a burden for the victims and stuff, we can't disagree that should be allowed. But they had also written that defendant James Crumbley should be aware of the fact that defendant Jennifer Crumbley has placed blame on him in jail communications. So that's interesting. I don't know what's being said there, but as you're familiar with by now, people are alleged to say a lot of things in jail communications, and some of those things they actually are dumb enough to say. I got to tell you, none of these things are really funny, but it is kind of funny because Darrell Brooks, when I was reading parts of the transcript of his jail communications about Erica and with his mom and all that, when he was trying to threaten and intimidate her, and he started trying to talk in a third person like it's not him and it's not her and these other people. But after a couple of minutes, he gets mad and frustrated, just gives all that up and starts talking about himself and her in the first person. He's not much, but he is mockable, I think. Yeah, that's right. I think her going back here again to the Kaitlin case, the Mo's situation that her friend did CPR for 10 minutes. And that's how traumatizing is that to do that and find your friend like that? It is awful. Yeah, absolutely awful. Yes, this video about her running and failing to jump a wall, but she gave it a shot, didn't she? She really gave it a shot. So it just didn't work out. Yeah, Brooks was kind of a loser in every way that I think that you can be, and that was another one. And of course, that case is still floating out there because it's been continued to December. Brooks' case involving it, trying to intimidate Erica, along with the other cases involving Erica. So let's go back here. So the Crumbleys are the parents of their son went into a school and shot people in the school, killed several students there. He was a student himself, and they had recently bought a handgun, and he got possession of it, took it to school, shot them. And, the circumstances are he was drawing pictures about it, hearing voices and things, and he was very mentally disturbed. But the charges of against the parents is manslaughter, and that's unusual because normally the intentional criminal act of a third party, in this case their son, breaks the proximate cause chain for purposes of culpability. So they had a lot of gyrations. There's been a lot of videos on that. If you check out David's channel on Making Law Simple, he's got some good commentary on this in terms of the issue with proximate cause. I went over their opinion and stuff like that, but they've lost that at this point. The case is going to go forward. They'll bring it up again if they get convicted, but they have to face trial. So now at this point, they will go to trial for whether they can be held responsible for manslaughter or not. And they are now splitting up a little bit on this. And it could be if one or the other is. It's not necessarily the case that they both are responsible for it if either is. And so that's why it may be a good idea for them to split up on this case. So I definitely think they were highly irresponsible with the firearms, but I also think it is truly a close issue on this proximate cause thing. And the Court of Appeals kind of dodged it and said, well, our decision here isn't precedent for any other case, which isn't something you really want to see in a criminal case because rules should apply to everybody. But they basically said the facts here are such that this isn't really a proximate cause issue. And I don't know that I agree with that, but also don't feel sorry for these people because they knew their son was highly disturbed, and they did allow him to take possession, or at least they were highly negligent in how they left the gun out so he could get possession of his semi-automatic handgun, some SIG or whatever. I mean, I'm all about guns. I got a lot of guns. We've got lots of stuff like that. And it is my responsibility to not give them over to mentally ill people, whether I'm related to them or not, or leave them laying around where anybody can just grab them, especially if I know they're hearing voices and things. But is that make me responsible for manslaughter? That's really the issue here, because there are other statutes that could have been charged in. Down here in Tennessee, well, I think down here may apply to some of the people watching, but you're just west of us. So how about that? We were over near there, or in there, not too long ago when we were at the Smokies, and I went up there to get this hat again after the last one I had blew off at Mount Washington. So we had to go to Mount LeConte to try and get another hat, and went up there twice. They didn't have it, but then somebody actually on the channel said, dude, get on their website and just order another one. I didn't want to do it without hiking back up there, but since I did hike up there and didn't have it, that's what I did. Now I have my hat again, so that's awesome. And maybe I'll be back at Mount Washington soon, and I'll find the other one somewhere, but I don't think so. All right, let's go with, we've been at this for a while. The counter says almost an hour, but we'll finish in an hour. My wife is laughing at me now. The You're So Dumb section, let's do a couple of these. And these aren't the greatest, but they're pretty cool. We'll get some good ones next week. We'll stick it with the bank robbery theme that we've been going with here. His name's Mincer, not Mensa. So this guy goes in to rob a bank, and he got a stack of cash from the bank, but you're not pulling one over on this dude. He realized that he got a die pack in there. He pulls that out, throws it back. So he's golden, right? He's got the money, but what do you want when you have money? More money. And when you have more money, you want more money. Well, he wanted more money, and he said, I want the money out of the cash recycling machine. And the clerk said, well, I'd be glad to give it to you. I definitely want to comply with everything you're saying, but the machine only works if I put the ID in it. So if you just hand me your ID, I can get the money out of it. And so that seemed reasonable to Mr. not Mensa, but Mincer. And he hands her his driver's license, the bank robber. He doesn't say, get your driver's license out. He complies and says, well, okay, that's reasonable to me. The machine needs my ID. Hands her his ID. She puts it into the machine because it reads it, records it, gives him this old money, and now the police have his ID. So I am disappointed in Mr. Mincer. That is not a smart criminal. They're not all hard to solve, are they? South Carolina is the best Carolina. And we may never agree on that, but I will say this. It is definitely in the top 2 of the Carolina. So we're close, at least, in that regard. But there are parts of South Carolina that, of course, are very cool. And there's a certain spirit in South Carolina of independence that is sometimes warranted and sometimes it can be troublesome. But they have some cool beach stuff, too. So I will say that for them. They ruined Bike Week at Myrtle Beach. That's really why I have some antagonistic attitude there. They ruined it. It took away the good parts of Bike Week. Thanks for recognizing 10,000 subs, and I appreciate that. I don't understand it, but that's cool, I guess. XO and 03 to his Tad. No, I'm way older than that, dude. I'm in the 80s. If you saw some of the pictures, that's old. That's, by God, that's old school. I mean, when I went through commo school, it was more, I had to learn Morse code first. From Belgrade, Serbia, an unknown European godforsaken country. It can't be that bad, can it? I mean, we got some counties like that around here, so we may have something in common there if it is truly that bad. But I know you guys have had some hard times, but hopefully things are better right now than they have been at some times. So here's some, it's gotten back to being good. I'm hearing on Bike Week. And just stay down in Emerald's Inlet area. Well, check it out then, because it's been quite a while since I went there. And you know what I'm talking about, when they had the big blowout and they didn't want it there and all that. And there are certain areas of South Carolina that don't like loud Harleys and things. Anyway, let's go to this guy. Now, this guy's a lot of things. Maybe he's a burglar. Maybe he assaults people and stuff like that. But don't call him a liar. Do not call him a liar. And he's got the tattoo of truth on. And it may be hard to read on the screen, but it says, all gas, no brakes. That's tattooed there. And he proved the truth of it as he was trying to elude police. And you can see a picture from the video up there where he rams his car into another one instead of stopping and swerving around it, that he just accelerated directly into a car. And he did hit his head. You can see it bleeding. So that's good that he didn't hit anything that was important, nothing that would really matter if it got hurt, only his head, which I think is not something that he uses a lot other than as a billboard for his tattoos. Again, a truthful guy. So you gotta give him that. It's South Palm Desert, California. That sounds pretty cool. From the South, Palm Desert, California. Well, you're from the South. Dude, I'm from the South, right? But I guess you have Southern California too. But that's just cool, right? That's not South like sweet tea South, like I don't know. All right. So I think that is most of this. That's all the cases for now. And I will check that AG thing on Judge Gull and catch back up on that, make a comment on it if I find something. And let's see what I got here. And that is going to be it. Thanks, everybody, for coming by, and I hope you have a great rest of your weekend. Sorry I was a day late, but I enjoyed it, and thanks, everybody, for spending time with me on Saturday evening. Thanks, bye.